So what's the first big mistake injured workers make when settling their workers' compensation case? And this is a biggie. One of the biggest ones that I see a lot of times is accepting that early offer. A lot of insurance companies know the complexity of a case or the possible exposure on a case. And sometimes they'll throw a half decent offer at you to entice you to just take it and run. So oftentimes it happens before you get a lawyer involved. And I've seen it happen a lot where case is a few months old and somebody calls me because they start having questions or they want to know if that offer is a good one. And I'm saying, well, let's think about this because it might not be. Listen, if an insurance company offers to settle your case for $10, I am obligated to tell you about it. And I will certainly go through the pros and cons of that settlement with you. 99.9% of the time, I do not recommend you accept that early offer. We can usually do better. Another big mistake that people make is thinking that the insurance company is on your side. Insurance companies are very good at this. They're very good at being nice to you and making you believe and think that they are there to protect you. The insurance company is there to protect the insurance company, number one, and the employer that it represents and insures, number two. And if there's a way to give you what they think you're entitled to for less than you think you're entitled to get, they're going to do it. You know, we just had a case recently. We had a gentleman who had a very, very significant severe injury, and the insurance company sent the nurse case manager in before I could even really get involved, and he fell in love with her. She's the best. She's here to help. And I said, she doesn't work for you. She works for the insurance company, and she's there to make sure to keep an eye on the treatment that you're getting and to try to trim costs whenever possible. So you need to be mindful of that. And the same holds true with the case adjusters. So you got to be very, very careful. Another huge mistake that we see sometimes is not negotiating. And it baffles me how often this happens. The dialogue when it comes to settling a case can go a lot of different ways. Sometimes we'll get an email or a call from an insurance company, or it happened in court, and they'll say, hey, is your client interested in settling the case? I'll say, well, certainly reach out and talk to my clients, and I'll have a discussion with them to see if it's something that they're interested in. Do you want to make an offer? And a lot of times they say, no, give us a demand first. That's usually how it goes. But I always like to get a number out of them first to see what their baseline is. And from time to time, an insurance company will make an initial offer. And they'll say, hey, we'll give you $15,000 to close this case right now. And listen, depending on your circumstance, $15,000 is a lot of money. And sometimes people say, you know what, that's going to pay my rent. That's going to get me back to square one. I'll take it. And you don't know how many times we'll start talking about it. Well, you understand a fee is going to come out of that. You understand you're responsible for future medical. And once you start explaining the ramifications of what's going to happen, then people start pulling back a little bit. But a lot of times people jump and they say, I'll take it. And if you don't have an attorney to have that discussion with you to make you understand what will happen, if you just take it, you're putting yourself at a disadvantage. As an attorney who does this, we're able to just have a better way of estimating the true value of your case. So that's why it's important to have a lawyer who understands the workers' compensation system. So what mistakes do injured workers make when deciding which type of settlement to use? Settlement is a very generic term. People use the word disability. Oh, when am I going to get my disability benefits? And sometimes people don't truly understand what the different forms of settlement are in the workers' compensation world here in New York State. And I'm going to give you an example on the primary two. The first type of agreement that we use is the stipulated agreement. And a stipulated agreement is an agreement. And we have a form called a stipulation. We call it the stip. It's a blank form. We put your case information at the top. Everyone signs at the bottom. In the middle is completely blank. And we fill in the blanks with what we want. And that could be 100 different things. We could stipulate to temporary benefits. So if we're arguing over what your level of disability was from your first IME to your second IME, rather than sit here and fight about it, we can just come to an agreement. And if everybody's on board, we could put it on a stip, sign it, boom, you get paid those awards, and that's it. That is a settlement of one portion of your case. So it is a settlement and your case still goes on. You can also settle permanent disability, whether it's permanent partial or the non-schedulable injuries that we discussed in the past, or schedulable injuries. Our doctor says you have a 35% permanent disability to your shoulder. Their doctor says you have a 25%. We agree to a 30%. We split it in half and give you the 30%, and boom, we could put that on a stipulated, and it'll be formalized by the court. You'll get your money and case closed. What are the benefits of a stipulated agreement? For the most part, you can reopen that case if you have a worsening in your condition. If your condition worsens, you do have the opportunity to have your doctor, with medical evidence of a worsening in your condition, reopen that case, and potentially you could pursue additional benefits if necessary down the road. Now, you contrast that with the other type of settlement, the Section 32. A Section 32 is a full and complete closure of that case. The only caveat to a Section 32 settlement is what's known as an indemnity-only Section 32. An indemnity-only Section 32 closes the indemnity portion of your case. And when you hear the word indemnity, think money, the money side of your case, but it leaves the medical side of your case open. So most Section 32s close out the medical and the indemnity, but sometimes in certain circumstances, it's more appropriate to leave the medical open and close just the money side of your case. But when you do close it with an indemnity only Section 32, that part of your case is closed forever. So if you do have a worsening in your condition, you cannot reopen that part of your case to get more money. The only time you can ever reopen a Section 32 is if all parties, including the carrier and including the compensation board, agree to do that. And in reality, neither will. The carrier paid you off to get rid of you, and the insurance company doesn't want to make bad law by reopening a case, so they're probably not going to allow it. They want to move on. So what are the benefits to doing that? Usually you get a couple more bucks because you are agreeing to close your case forever. The example I wanted to give you, we have a client who needs a total knee replacement, but he doesn't need it right now. His case is finished. He's done with his treatment. Physical therapy is done. And his doctor said, you're due for a total knee replacement. You could get away with not having one now or for the next few years. You're going to need it at some point in the future, but you just don't need it right now. And that client said, look, I want to settle my case. And what should we do here? And you know what I thought? Well, this is perfect for a stipulated agreement. Let's find out from your doctor what your level of permanent loss of use is to that knee. We'll see what the insurance company has to say. Let's work out some resolution of what your scheduled loss of use is. Let's close the case, get you some money, and let you move on with your life. And if you need a knee replacement, if your condition worsens, well, then maybe we have to reopen the case in 3 years. You do have a limitation of 18 years, so you can't go too long, but that's the only thing to really keep in mind. So in that circumstance, based upon that set of facts, it makes more sense to do a stipulated agreement on schedule loss and not do a full and final Section 32. The other types of settlements that we see sometimes, you have the indemnity only Section 32. Usually that's when we structure the medical side of a case. So if we do a full and final Section 32 and we close the indemnity side for $100,000, but the medical side was also very valuable, let's say that was $100,000 as well, insurance companies might choose to structure that with an annuity, which pays you over time to get you that money because you need it for the rest of your life. And sometimes we can use that to get you a little bit higher settlement overall because we're saving them money by allowing that annuity to happen. What mistakes do injured workers make when calculating the value of their settlement? If you're doing a full and final, we're talking Section 32 settlements now, you have to factor in the cost of your future medical care, medications, vocational rehab, Social Security is a factor, any attorney's fees that you might have to pay down the road, cost of living increases are an important factor. So you have to be able to take a look at the big picture here. It's not just getting money and running. You need to make sure you're prepared and you're set to take a settlement and move on with your life in a positive direction, because client calls you 2-3 years later and they say, hey, I need more money. I spent all my Section 32 money, and it's a heartbreaker to tell them, sorry, nothing I can do to help you. Other mistakes that people make when calculating the value of their settlement is overvaluing. And this is why having an attorney, again, is so important. And sometimes you say to somebody, well, what are you looking for? And they say, I owe 6 months worth of rent and I owe $50,000 on my credit card. I want $750,000. And I tell them, you're not being realistic. I understand what you owe, but there's nothing in the law that provides compensation for that. So you need to keep the valuation of your claim reasonable. We use a term called non-starter. If you go and ask for $500,000 on a case that's worth $50,000, it's a non-starter. Undervaluing your claims, like we said before, is also a problem. Miscalculating. What's your average weekly wage? What's your lost time? What's your overall level of disability? Those are the three most important factors in determining case valuation. And degree of disability is what's your level of disability as you've been getting your treatment, and what's your level of permanent disability once you've been classified. Those are the big factors in determining value of a non-schedule case. Understanding the difference between a schedule and a non-schedule case, also very important. Loss of a pinky toe, the least valuable appendage in the schedule chart. You lose a pinky toe, there's all sorts of problems that come from the loss of a little baby pinky toe. Yeah, you're not going to be the same, but you're not going to get benefits for the rest of your life. You're not going to get classified with a permanent partial disability, most likely. You're going to get a schedule loss award. So understanding the difference is very, very, very important. What do a lot of injured workers fail to understand about their workers' compensation settlement? They misunderstand what you can look for when you're settling a case. People look for value. They look for money. They look for settlement of things that are not settlable. Pain and suffering is the biggest one. I understand. I've had a workers' compensation case myself. I do understand it, but it's not compensable. You can be in the most intractable, worst pain in the world. You could have had the most horrible accident, the most horrible injury. Pain and suffering in New York State is not compensable. Loss of enjoyment of life, not compensable. Punitive damages, not compensable. Workers' compensation, by definition, will not make you whole. The most you're going to get for a week of lost time is 2/3 of your salary. So by definition, you're already operating at a loss. You're working from behind. So expecting that you're going to get your full salary back. It just doesn't happen. And you need to be conscious of that. You need to be mindful of that, because people all the time will say, I was earning $100,000 a year last year. Well, you're not going to earn it on comp, which is why, like I said before, in the work search realm, if you're able to go back at light duty, sometimes it's the best thing to do, because you're going to get some money out of it, and you're still going to get workers' compensation if your lawyer can prove your reduced earnings are work related. So you have to have reasonable expectations. One thing that people don't expect and happens all the time, New York workers' compensation benefits, financial, monetary, indemnity benefits, like we said before, are tax-free. So that's kind of a perk. We base your rate of compensation on your gross average weekly wage. We look at your gross salary, your pre-tax salary, and you get up to 2/3 of your gross salary tax-free. So that's a little bit of a perk to kind of bring your compensation rate closer to what your earnings were. But you will not get 100% of all of your outstanding benefits. We do the best we can to get you as close to that point as possible, but by definition, you're operating from behind. Sometimes in certain circumstances, also, the benefits that you receive while you're out of work, while you're disabled, get deducted from your final award. Schedule loss of use cases. So if you have a 10% schedule to a shoulder, you're entitled to 31.2 weeks of compensation payable at that maximum 2/3 rate. If you were out of work for 6.2 weeks and you were paid total compensation for that 6.2 weeks of lost time, when it comes time to pay you for your schedule, they're going to take a credit for that 6.2 weeks and you're going to get 25 weeks because you already were paid 6.2 weeks of that. So they take credit for your prior payments. So that's something to expect as well. Reasonable expectations are very, very important, especially when it comes time to settle your case, which is why having an attorney who can explain it to you so you understand it and you don't get blindsided by this is so important. Moving on, what mistakes do injured workers make after receiving their workers' compensation settlements? And this is what we discussed before, mismanaging funds. You have to plan for the rest of your life. I've had clients take their settlements and say, hey, do you have a financial planner that I can call? Because I got all this money now and I want to know what to do with it. I'm not just going to dump it in the bank. Yeah, man, call somebody who knows what to do with your money and prepare for the rest of your life. You can use that money to make money to live off of. You can use that money for a lot of different things. By the same token, there are people that go to Bora Bora and come back to me a year later and say, hey, it's all gone, but damn, do I have a nice tan? Yeah, but now you're shit out of luck. So you need to be very mindful. We had a client years and years ago, and granted, it was a horrible injury and the third party settled, but all I remember is him pulling up in front of the board in a pimped out Range Rover, iced out gorgeous watch, beautiful clothes, and he came sashaying into the board for a hearing, and I'm like, Jesus. And what happened? Ran out of money. Part of when you settle a case, if it's a full settlement and you do incur medical expenses in the future, you have to monitor your medical. You have to pay for any future medical care, especially if there's a formal Medicare set aside. You have to keep records of the money that you're spending, and you need to spend in accordance with the medical treatment guidelines. So if you settle your case and you keep going for ongoing chiropractic treatment, and I don't know the exact number that the New York medical treatment guidelines authorize for a chiropractic visit, let's call $50. If you go to a chiropractor who says, well, I will never take $50 for a chiropractic adjustment, I charge $150, and you go paying him out of your pocket $150. If you run out of money and you go back to Medicare and say, hey, Medicare, you told me to set aside all this money, it's gone. They're going to say, you've been paying this schmuck of a chiropractor triple what you're supposed to be paying him. We're not going to give you anything. Go get your money back from him and keep going. So you need to be very mindful, spending properly, the right prices, and setting money aside according to the Medicare set aside. It's tricky, and you need to talk to your lawyer about that. What's the absolute biggest mistake injured workers make when settling their case? And honestly, got to get a lawyer who knows what they're doing and who can guide you properly. The insurance company is not there for you. They're there for them. And they will take advantage of you if you don't have somebody protecting you. They have teams of attorneys. You should have an attorney helping you, because you don't know the true value of your case. Your lawyer can help you figure that out. You don't have the experience of negotiating a settlement, and you need to know the right time to settle the case also. As an attorney, as much as I love going to court and I love battling with the insurance companies and taking testimony and taking medical testimony and showing an insurance doctor where he was wrong and where our doctor was right, I also love sitting down and just laying it out in front of me and figuring out the value of a case, and then nailing an insurance company and just saying, look, you're offering us this, but you forgot about this, and this, and boom, we start, values start going up and up and up. That really makes me happy and feel good as an attorney. And you should want an attorney who loves what he does and takes pride in that types of results. So if you have any questions as to what the ins and outs are there and you want to give me a call, 212-406-8989. Stay safe, stay warm, and enjoy yourselves, folks. Thanks so much. Have a good night.